Hello, everyone. Tony Vellini. I'm here with my colleague Karen Hart. Uh,
Hi
we're going
there.
to we're going to talk about whether Roe v. Wade is still the law. Now, Karen and I, our professional focus is mainly teaching technology law, data privacy, and cybersecurity, but we think this is a very important issue, and we'd like to talk about it today to hopefully dispel some misperceptions that might be out there in the general public. And so, Karen, um, here's the first question. Why did you want to do this video together?
Well, Tony, there are a couple of problems right now, and I think it's misperceptions on the part of the media and the public about what's going on. And this recent U.S. Supreme Court ruling on a case involving that Texas anti-abortion law and the earlier decision of Roe versus Wade. And I think that, first of all, people are under the false impression that somehow Roe versus Wade is no longer the law, right? And that's simply not true. And we want to cover that and exactly why. And the second thing is that this decision has led some people to accuse the Supreme Court of political motivations in making their decisions. And that's not true either. And so I want to address that as well.
Mhm. And so, is Roe v. Wade still the law in Texas? And the related question is, does Texas have to follow the U.S. Supreme Court, Karen?
Well, Texas has to follow any rulings by the Supreme Court. So does every other state. Okay. Every court in this land and every person in this land has to obey the rulings of the U.S. Supreme Court. No one is accepted from that. And yes, Roe versus Wade is still the law in the land because it was a decision by the U.S. Supreme Court that the U.S. Supreme Court has not overruled. And this recent ruling in that Texas case did not address Roe versus Wade at all, let alone overrule it. And in fact, in the opinion, they say we're not addressing Roe versus Wade and the constitutionality of the statute. It was a very limited, narrow ruling.
Yeah, it was on a procedural issue that we'll talk about, but
Yep.
Karen, you make the correct point. The U.S. Supreme Court is the supreme law of the land. And so let's dig in some more. Recent Supreme Court case, it did not overrule Roe v. Wade, right?
That's correct. Now, their ruling about denying the application was simply based on the fact that the lawyers who were representing Planned Parenthood and brought the case had sued the wrong parties. And that was the real reason the case was essentially thrown out of the Supreme Court.
Yeah, so people see the case getting thrown out and they think Roe v. Wade is overruled. That's not the case at all.
They didn't rule on that. All they ruled on was the fact that the lawyers didn't do their homework. They sued the wrong parties.
And who did they sue, Karen?
Well, originally they sued a judge, a state court judge, a county clerk who's responsible for the court filings, and a private person who was an anti-abortion activist. And this was inappropriate because you don't sue the judge and the county clerk who were just involved in hearing a case. They're not a party to the case.
Mm-hmm. And, I like to think of a referee in a sports game, right? Let's say you're playing football. Your job is to essentially fight the other team, compete with the other team. If you start fighting with the referee, that usually doesn't work out too well. Isn't that what happened here?
Yeah, exactly. That's not how it works. So, if you think a law is unconstitutional, you can oftentimes file suit against the state. And have the judge hear that case and decide the issue, right? But you don't go and sue the judge.
Right.
So
Yeah.
what they should have done, what the lawyers should have done, is they should have filed what we call a declaratory action, seeking what we call a declaratory judgment. And they filed that suit against the state. And in fact, the state of Texas has a law providing for parties to do that. Planned Parenthood could have done that, or rather their lawyers could have done, and they should have, in fact, filed the declaratory action and named the state of Texas as the defendant instead of a judge and the county clerk. And Well, the U.S. Supreme Court threw it out because, frankly, on a technical point of law, what we call standing, neither the county clerk nor the judge, the state court judge, had actually been involved in the injury to Planned Parenthood, the injury that it was claiming. They weren't responsible. So they were claiming, that is, Planned Parenthood was claiming that they were injured by the statute, which was passed by the legislature of the state. And so that's why they should have been suing the state in a declaratory action.
And so we have a very simple visual aid. Planned Parenthood should sue the state of Texas. The judge is the referee. You fight with the referee, you get thrown out of the game, right?
Generally speaking, yeah. Now, there are instances where you could sue a judge, but that's getting off a little off tangent here. But that's only essentially, in a nutshell, when a judge is refusing to obey a law. But that's a different point.
Yeah, and there are cases where somebody can go to federal court and seek an order against a state court judge to apply the law correctly, but we're not getting into that too much.
Hey, in fact, they could do that within their own state courts. They don't even have to go to federal court.
Yeah.
Okay.
So, okay, Karen, if Planned Parenthood sued the state of Texas, arguing statute unconstitutional, how do you think it could work out or should work out?
If Planned Parenthood sued the right party, then courts would have the opportunity to find the statute unconstitutional under Roe versus Wade. And the courts are actually already addressing this issue. We believe that that's going to be the ultimate result, is that this statute is rescinded. Right? It's declared unconstitutional, and it's therefore just rescinded. Right? It's no longer the law. And in fact, this morning we looked at a federal injunction, issued by a federal district court in Austin, declaring the statute unconstitutional and prohibiting enforcement of it. However, we're curious if it might have some procedural problems from certain aspects of the decision, but we'll see how it works out with the Fifth Circuit Court of Appeals and any other courts that might become involved in the case.
Okay, so Karen, is the U.S. Supreme Court politically motivated when making decisions?
Absolutely not. I know people are accusing the court, and some of the justices have gone on record saying we're not being political, and it's true. They have no incentive for this. Every incentive is for them to really follow the law when making a decision. Remember, these decisions stay in the books for a long time. So whenever they make a decision, it's quite a legacy. Supreme Court justices are appointed for life. They're not politicians. They don't run for office. They don't get campaign contributions. They're not allowed to have them. They don't run for office. They don't need anyone's vote, right? They've been appointed, so they never run. They never need anyone's vote. And their job is simply to decide cases and decide the law based on the principles that we teach in law schools. So, as I've mentioned before, the justices are all people, so they do make mistakes. And I've certainly read Supreme Court opinions where they got something wrong. But I have to say, I've read a whole lot of Supreme Court decisions, and it's very rare when they make an incorrect decision. But they have acknowledged that from time to time they will overrule themselves, like a later session of the Supreme Court will overrule a decision from an earlier session. That does happen. It's very, very rare. So really the bigger problem is really trying to understand their opinions, because they're almost always very legally complex. And I think that's a bigger problem. It's more difficult for people to understand what it is they're trying to explain, and what it is they're trying to espouse as the reasons for their rulings.
Mm-hmm. Bonus slide. Okay, so based on what we talked about, what are two elements of standing that lawyers should worry about when they're filing a lawsuit?
Well, the first thing is you have to worry about who you're suing. You have to sue the right party. And the party that you're suing is the one who is responsible for the injury you're complaining of. The person to whom that injury is traceable. That's the language of the court, traceable, meaning who's responsible for the injury. If you don't sue the right party, you get thrown out of court. The second thing is you don't file a lawsuit, and because you can't file a lawsuit until the injury has either occurred or is imminent, meaning it's really right about to occur.
Yeah, and this whole idea of an imminent injury, we probably have that here with this statute. And I would think oftentimes if a plaintiff is alleging that a statute is unconstitutional, that might be sufficient to show the possibility of an imminent injury, right?
Right. And it's not just whether the statute is unconstitutional with regard to injury. It's also, like in this case, it's whether it's, it will interfere with someone's constitutionally protected rights, right? It's one thing if there's a procedural problem with the Constitution, let's say that something should be done by the executive branch as opposed to the legislative branch. There's a whole line of cases along that. But the real question today was a question of injury to people, and it involved their constitutional rights. So I know people are talking about individual rights, this right or that right, like the particular issue involved. But I really think that people should look at it in the context of what the rule is in law. And the rule is very simple. It doesn't matter which constitutionally protected right is involved. If you have a constitutionally protected right and someone made a statute that really interferes with that right, then you've been injured, right? It doesn't matter which right, which constitutionally protected right we're talking about. And to talk about it, this right or that right, whether we're talking about right to bear arms, or freedom of speech, or freedom of religion, that really drags us down to the level of political discussion, which is what's problematic here, because the court's not deciding on that. They're simply deciding on the fact of whether a constitutionally protected right is at stake here and being taken away by a statute.
Mm-hmm. Now, Karen, we have a double bonus slide.
Uh-oh, it's the daily double.
The daily double. Why do suspect laws like this get passed? So we look at this Texas statute. It looks clearly unconstitutional. So what's going on?
Well, this is lobbying. All right. This is political grandstanding. These are legislators who are paying attention to some group for some political reason, and they're passing this law simply to please that group of people, but knowing full well that the law doesn't meet constitutional muster, and it does happen from time to time, and it's wholly inappropriate, and it should never occur, because a constitutionally protected right, it should never be the discussion, the subject of political discussion. You have a constitutionally protected right, and then the discussion should end there.
Yeah. Well, Karen, thank you for doing this video with me. I think this should be very informative, especially for the general public trying to understand what's going on with this issue. So thank you so much.
Thanks, Tony.